Welcome to the webinar. I hope that you find this useful. As detailed in the advert, we're going to, I suppose, take a bit of a broad brush approach in terms of trying to define insolvency within the construction industry, what it looks like, various procedures that you might encounter, and we're going to look at some of that in a bit of detail. Appreciate that going through a lot of this information, it can be a lot to consider just in the moment, and it may be that, as Vincent said, there's some time for questions at the end. You may have some questions after the webinar or things that come to mind after, and by all means, please feel free to get in touch with Kathryn or myself if you have any queries. Our details will be available, made available today, and also on the slides that I understand will be made available after the webinar. In terms of our firm, if you're not familiar with us, Mills Selig is a local and independent law firm. We're experts in all matters of corporate and commercial law and are always committed to offering a comprehensive legal advice, no matter the complexity of the case. We'd like to take a 360 approach to any matter, meaning our clients and you have access to a full specialist team who can provide tailored advice specific to your needs. And there's some details there in relation to the firm. So that's our spiel in terms of Mills Selig. Moving on to our agenda for today, as mentioned, we'll go through the various insolvency proceedings and try and bust some of the jargon in relation to that, so you and your business have a better understanding of what you're dealing with whenever you're either facing or have a customer who's facing insolvency proceedings. A review then of recent key developments in insolvency law, take some time to look at that, and then we will look at debtor and creditor considerations in insolvency. Kathryn will take us through that, and then, as mentioned, at the end we'll have some time for questions. So, jargon busting, insolvency really, in summary, describes the inability of a debtor to pay its debts. So when it comes to individuals, we use the term bankruptcy. When it comes to companies, you hear terms such as liquidation or administration being used. For individuals or companies, there is the possibility of a voluntary arrangement. So that would either be an IVA or a CVA, and they also are a common alternative to bankruptcy or liquidation or administration. In terms of the order of priority, this is very important in terms of considering what you may receive out of an insolvency proceeding. So the order of priority, first and foremost, fixed charge holders receive payment of their debt. So that would usually be a fixed charge attached to normally property of some description, or in some cases, perhaps some plant and machinery. Then secondly, the insolvency practitioner, their fees and expenses are paid. Before thirdly, the preferred creditors, and as we'll summarize later in our presentation, that now includes the revenue. And fourthly, floating charge holders, those are charges that you usually see in the description as a debenture, which effectively floats and only crystallizes whenever the insolvency procedure begins. So that might relate to things like stock or trade debtors. And then fourthly, unsecured creditors, and that's where most businesses find themselves. They don't have a form of security, and effectively they have to wait until all the secured creditors are paid before they get anything. And then finally, shareholders of the business, if there's anything left for them, they're last to receive any payment. Describing some of the procedures then, start with liquidation. So this is used to wind up a company and realize and distribute its assets to creditors and shareholders. Liquidation of a company can be voluntary or compulsory. When it comes to voluntary liquidation, it's initiated by a shareholders' resolution to wind up the company, and there are two main forms. Firstly, members' voluntary liquidation. sometimes referred to as a solvent liquidation. So a member's voluntary liquidation can only be done in situations where creditors will be paid in full. And then in an insolvent situation, creditors' voluntary liquidation, or CVL, would be the proposed course forward. An MVL then must be accompanied by a statutory declaration. That declaration must say that the company is solvent and that it can pay all its creditors within 12 months. A liquidator is nominated by the shareholders and approved by creditors in the case of a CVL. So often you'll see if a company is proposing a CVL that you as a creditor will be invited to come to that meeting and to support the appointment. Compulsory liquidation then is initiated by the presentation of a winding up petition to the court. And in the event that a winding up order is made, the official receiver, more commonly known as the OR, automatically becomes the liquidator of the company. The official receiver operates out of the Insolvency Service, part of the Department for Economy. If the company has assets that can be realized for the benefit of creditors, it would be normal that the official receiver appoints an insolvency practitioner to act as liquidator. And that appointment could happen pretty quickly after winding up, but in some cases, it could be several months down the line. In the case of a compulsory liquidation, any action or legal proceedings against the company in liquidation cannot be initiated or continued without leave of the court. So that's an important consideration if you are indeed involved in proceedings with a company that then goes into liquidation. Looking at administration then, this is a procedure that's commonly used as a way of facilitating the rescue of a company or the better realization of its assets. One of the key benefits of administration is that it does allow an insolvent company to continue to trade with some level of protection from its creditors through the statutory moratorium, effectively freezing any action pending the outcome of the administration. This moratorium prevents creditors from taking legal action against the company or enforcing their security against the company or its property. The main objective of administration is to rescue the company as a going concern. However, if this is not possible, then the second objective is to achieve a better result for the company's creditors than winding up or liquidation of the company without it first being in administration. The third objective is to realize property to distribute the proceeds to the secured or preferential creditors. And this only applies if the first two objectives are not possible, and it will not unnecessarily harm the interests of creditors as a whole. An administrator can be appointed either by an out-of-court procedure or by a court order. So an out-of-court appointment can only be made by the company through its directors or shareholders, or by a qualifying floating charge holder, usually the lender there that has a debenture over the company. If it is an out-of-court appointment by the directors or shareholders, they would always need to seek consent from the floating charge holder in relation to the appointment. An application for a court order can be made by either the company's directors, or one or more creditors of the company. The administrator himself or herself has extensive powers to manage the affairs of the company, and also enforcement powers, such as bringing an application to court to challenge any pre-insolvency transactions. And so one of the key benefits of appointing an administrator is that the creditors can be confident that there's somebody in there who's independent and can properly investigate everything and take appropriate action as is necessary. Pre-pack administration may be a type of administration that you are familiar with or you've heard about. This is a procedure whereby a company arranges a deal to sell its assets to a buyer before appointing administrators to facilitate the sale. It is a very powerful legal way of selling the business onto a trade buyer or third party, and typically a good outcome for secured creditors, but can be quite disastrous for unsecured creditors. So essentially, in a pre-pack administration, the company may be looking at what is valuable within the company that they want to keep. I guess another key benefit is that employees can, it secures jobs for employees if they can save part of the business. But the problem is with the part of the business that is failing or a loss leader, that might disappear. And as a result, any unsecured creditors tied into debts connected to those companies are likely to experience a significant loss. Phoenix company issues are addressed in the administration's restrictions on disposals, etc., connected parties regulations. These currently aren't in force in Northern Ireland, but this is usually something that certainly creditors want to know a bit more about in terms of if it looks like the company is selling to an associated company, then there maybe will be a deal of suspicion around the transaction. But there is the prospect of that certainly happening, and there are ways and means from the administrator's point of view to satisfy themselves that that is the best possible outcome. And so the pre-pack administration usually involves some kind of independent review of the transaction to make sure that it is the best possible outcome for creditors. Company voluntary arrangements then, a CVA is a contractual agreement between a company and its unsecured creditors. The main aim of the CVA is to enable a company in financial difficulty to propose a compromise or an arrangement with its creditors. In most cases, a CVA is commenced by the company's directors. However, if the company is already in administration or liquidation, it can be proposed by the administrator or the liquidator. In order for a CVA to be approved, it requires 75% of the voting creditors who respond to the invitation to vote, and at least 50% of those voting in favour must be unconnected with the company. So quite often what happens is whenever a CVA is proposed, not all of the creditors will really engage in the process, and that's why it's important to consider that if you have a strong view about the CVA, that you do engage and levy your vote, because if you do not vote, that is not seen as a rejection as such. And so for that reason, in some cases, CVAs can be approved by percentage-wise a small amount of creditors, but what ultimately is the 75% voting majority that is required. An approved CVA is then supervised by a licensed insolvency practitioner, and although the directors of the company remain in control, they must fully cooperate with the IP to ensure implementation of the terms of the CVA. So typically CVAs usually last somewhere between 3 and 5 years, and their cooperation, the cooperation of directors is vital. And in fact, if they fail to cooperate or fail to implement the terms of the CVA, then there is usually a power for the IP to wind up the company. There's no impact on employees, and the procedure therefore does not interfere with the company's ongoing business activities. And then importantly, the approved CVA is a binding agreement between the company and all of its unsecured creditors. And this includes unsecured creditors who did not vote, and even those unsecured creditors who did not receive notice of the proposed CVA. Quite common, I would receive inquiries about situations such as that. So there is a requirement on the nominee in relation to the CVA to circulate the CVA to all known creditors. But if for whatever reason the one or more of the creditors did not receive the proposed CVA, that is not in itself a reason to challenge the arrangement. There are in fact very limited grounds available to challenge a CVA, and obviously specialist advice would be required in each case. Moving on then to some of the recent developments that we've seen in insolvency law over the past number of years. The main development that we've seen is what's known as CIGA 2020, the Corporate Insolvency and Governance Act, which came into force on the 26th of June 2020, which we'll all remember was shortly after the pandemic of March of the same year. Alex Sharma, who was the business secretary at the time, said this: our overriding objective is to help UK companies which need to undergo a financial rescue or restructuring process to keep trading. These measures will give those firms extra time and space to weather the storm and be ready when the crisis ends, whilst ensuring that creditors get the best return possible in the circumstances. And so the legislation was not a response to the pandemic as such, but whenever the pandemic started, there certainly was a great deal of urgency in terms of getting that through, as obviously we were experiencing a particularly difficult time for all businesses, and there was an additional need there in terms of protecting businesses and allowing them to continue to trade. CIGA then introduced a number of permanent and temporary insolvency measures. The permanent insolvency measures, which I'll cover briefly in a minute, include moratoriums, restructuring plans, and termination clauses in supply contracts, something no doubt of interest to the construction industry. Temporary insolvency measures, these now have all gone, but there were some temporary restrictions brought in relation to winding up petitions, suspension of liability for wrongful trading, and company meetings and filings. In terms of the moratorium, so this provides some breathing space for companies in financial difficulty. There is both an out-of-court and in-court entry route, depending on whether the wind-up petition has or has not been presented against the company. It involves an initial 20 business day period, which can be extended by a further 20 days without any consent, or up to a year with creditor consent or a court order, or indeed longer than a year if sanctioned by court. Entry into and extensions of the moratorium are overseen by a monitor who would be a qualified insolvency practitioner, but the debtor remains in possession. The proposed monitor then must provide a statement that, in his or her view, the moratorium would result in the rescue of the company as a going concern. Moratorium on payment of debts due at the date of commencement of the moratorium is one of the implications, and also payments to creditors in respect of debts during the moratorium period need to be paid. So that's important to consider. But we actually haven't seen any moratoriums, as far as I'm aware, in this jurisdiction to date. That point about creditors needing to be paid in respect of their debts during the moratorium may at least give some comfort in that the position of the creditor should not worsen during the moratorium period. The second permanent measure introduced by CIGA was the restructuring plan. To be eligible for a restructuring plan, the company must show that it is encountering or likely to encounter financial difficulties, and a proposed compromise with creditors intends to eliminate, reduce, prevent, or mitigate the effect of the difficulties. So again, this is not something that can only be considered whenever a company has been presented with a petition or that there's an immediate threat, but indeed where they can show that they are likely to encounter financial difficulties. This is something that can be looked at. The process involves an application to the court, followed by a meeting of creditors, 75% voting majority required there, followed by the court sanctioning the plan. One of the key elements of the restructuring plan that is new is this power to include a cross-class cram down that binds all creditors, including a class of dissenting creditors. This is similar to what we see in the bankruptcy provisions in the US. So essentially, you could have a situation where most of the group of unsecured creditors are more than happy with the plan, but maybe a dissenting class are unhappy. So one example could be where the HMRC, for example, are opposing the proposal, but all other creditors are happy, they could potentially then be put into a class of their own, and subject to the court being satisfied that this is the best outcome for creditors, it may be possible for that proposal to be sanctioned, even if the revenue are objecting to it. Termination clauses then in supply contracts, any contractual provision which envisages the contract being terminated, or any other thing that would take place, or the supplier being able to terminate the contract or supply or do any other thing, ceases to have effect. So a contract can be terminated if the office holder or the company consents, or the court is satisfied that the continuation of the contract would cause the supplier unnecessary hardship. The supplier, however, cannot require outstanding charges to be paid as a continuation of the supply in the insolvency procedure, which may be a common enough instance where, in order to continue to trade with the company whilst they're in these difficulties, the creditor quite rightly might insist upon some sort of lump sum payment towards historic debt, but in this case will not be entitled to rely upon that, or indeed require that, and may have to continue to provide the supplies to the customer. One thing I will say about this is that, as I already mentioned, the requirement would be that any supplies made during the period of the restructuring plan have to continue to be paid for, and there can't be any shortage in relation to that. So again, the principle being that whilst the creditor may find that historic debt is in difficulty, they will not have their position worsened by continuing to contract with the insolvent company. There were a couple of temporary exemptions for suppliers facing hardship, and some smaller suppliers, they're listed there, but they're really irrelevant now, as the temporary exemptions or the temporary clauses are no longer in play. The key point to consider then really is that suppliers need to be probably more diligent than ever to ensure that they are comfortable with the buyer's creditworthiness, knowing that they may find themselves in a position where they're exposed to historic debt and have to continue to supply the debtor, even though in most cases they would want to cease doing that. Winding up petitions then, so the temporary restrictions have gone now. They went some time ago in England and Wales. It took a lot longer before they were dropped in Northern Ireland. Only in April there of this year that the creditor winding up petitions were accepted once again by the bankruptcy court. Something that is unique to our jurisdiction is that a winding up petition can only be presented on foot of a court judgment in respect of the debt. So that is not law as such. That's the guidance that's in place at the minute. But essentially, you cannot, as you previously could have, issued a demand and then followed up with a winding up petition. You must first seek an order from the court in respect to the judgment before you proceed to wind up the company. That adds an extra layer of cost to the procedure, and obviously slows down the procedure as well, which probably makes it a bit more unattractive from a creditor perspective. The revenue HMRC are different in that they do not require a judgment before presenting their petition. And indeed, perhaps unsurprisingly, since April of this year, we have seen more HMRC winding up petitions being presented to the court than other creditors. Whilst that would normally be the case in any event, it has been significantly higher, probably due to the fact that HMRC, unlike other creditors, do not have to seek a judgment. The Crown preference position changed in December of 2020, which ranked HMRC ahead of floating charge holders and indeed unsecured creditors under the Finance Act 2020. So their elevated claim status will relate to PAYE, employment, national insurance contributions, and construction industry scheme deductions and VAT. HMRC claim cannot be capped by any amount or time, and the Act will apply retrospectively. And as many legal professionals commented at the time, this really is a bit of a game changer, because the Crown often are a major unsecured creditor, and indeed in some cases they would be more challenging to persuade in relation to a voluntary arrangement, partly because when it comes to HMRC, it's not just the commercial outcome that they're interested in, but they're also interested in what the performance history of the company has been. So if they are serial offenders for filing returns, for example, then that will always work against them. So we're in a situation now where the revenue cannot be bound into some form of arrangement in the same way that they could have previously, provided all the other unsecured creditors were comfortable. It's hard to see exactly how this will play out, partly because the winding up petitions are only really back in play now for 6 months or so, and maybe over the course of the next year we'll see more of the implications of Crown preference play into insolvency. You may find as a result there's fewer CVAs coming through, and possibly an increase in pre-pack administrations, which is one way of circumventing the challenge of dealing with the Crown preference. So implications for insolvencies with regard to HMRC. So they're typically one of the largest creditors. They cannot be bound by a company voluntary arrangement. And as mentioned, the new rules may stimulate increased number of other insolvency procedures. And indeed, you may find as a result, as I mentioned, with the restructuring plans under SIGA 2020, that they start to come through. Again, we're still quite fresh in relation to this and not really seeing much activity at this stage, but that's not to say in the years to come that there won't be increased attempts to use, for example, restructuring plans as a way of dealing with this problem from the debtor perspective. I'll just hand over then to Kathryn, who will conclude our presentation today with some debtor and creditor considerations.
Morning, everyone. So I'm just going to start off by running through some debtor considerations. As we're all aware, there are an increasing number of construction companies at risk of insolvency at present. And if you do find yourself in that situation, the first thing we would advise is an informal assessment of a business recovery plan. Look at how you're going to manage the debt if it's starting to mount. Be proactive and deal with the situation logically, and don't wait for your creditors to take action. The next thing we would say is early engagement with stakeholders. So maintain good relations with your creditors, keep them up to date and explain the situation to them and let them know that you're trying to resolve it. If nothing else, this will reassure them, but it may also make it less likely that they take formal action to recover their debt. The next thing is to improve cash flow as much as possible. So explore different ways to raise funds, for example, cutting out any unnecessary costs or making sure your own customers pay on time, carry less stock or liquidate assets. The next thing is early engagement with insolvency specialists. So we would really advise you to seek expert advice early on from an insolvency practitioner. They will be able to set out the options available to you and advise you on the best one for you. And then finally, make best use of this time to make a restructuring and recovery plan, so you can try to save the company before you're forced into a corner by creditors and don't really have much choice. So now we'll move on to creditor considerations, and this is to limit or avoid bad debt. So firstly, seek to limit exposure where possible when the debt is unsecured. So just try to keep your debt as low as possible. Next, engage a solicitor at an early stage to pursue debts. So in the first instance, a letter before action can be sent, which may prompt repayment in full, which would be the best outcome, so that you don't have to take any further action. But also it may push a debtor to engage in settlement discussions. And then next we have obtain court judgments. As Richard has already said, you're now required to obtain a court judgment in respect of the debt before you can issue winding up proceedings. Next, we have review supply contracts to ensure maximum protection. So have clear contracts with strict payment terms and conditions for late payment. Another thing to consider is retention of title clauses. This gives you some extra security in terms of exposure when you're not being paid upfront, as it allows you to uplift goods. And finally, we would say give serious consideration to compromise settlements when dealing with a distressed company. So weigh up your options and consider the asset position of the debtor company. If they are offering something, it could be better than nothing, especially if you're having to pay costs to pursue the debt, which you may not get back. So really do consider if something's on the table, it may be better than getting nothing. And now I'll pass back to Richard, who is just going to summarise and take any questions.
Yes, thanks, Kathryn. So just in summary then, we expect that we will see an increased number of insolvencies now that winding up petitions are actively being brought, especially those being brought by the revenue. CVAs, which had historically been a popular restructuring tool within the construction industry, are potentially under threat due to the HMRC preferential status that I outlined earlier. And so I suppose in summary then, it could be a challenging time ahead for unsecured creditors of insolvent companies. I hope that the information that we have shared with you this morning is helpful, just even in terms of having a better general understanding of what you're facing whenever, either from a creditor or debtor perspective, you're looking at insolvency. And obviously there's it can be a bit of a minefield. I'm not just saying that so that you will look to seek legal advice, but it is quite a complex area, and there's a lot to consider whenever you're either find yourself in an insolvent position or close to an insolvent position, or indeed are dealing with other insolvent companies. And so can't recommend enough that whenever this happens, that expert advice is sought either from an insolvency practitioner or legal advice in order to help you understand how best to engage with that process. I'll hand back now to Vincent, who will take us through any of the questions. And as mentioned before, more than happy for you to contact either Kathryn or myself later down the line if you have a more specific query that you would like us to consider. Thank you very much for your attention today. Hope we didn't bore you too much, and thanks again for attending.
Thank you. Thanks, Richard, and thanks, Kathryn, for that. That was great. Minefield, I think, is a good word for this in terms of the complexities of it all. We do have a couple of questions that came in, which is great. First one would be, what do you predict that the next 12 months will sort of look like around this sort of area?
Yes, well, thanks, Vincent. As mentioned there at the end, the reality is that we expect to see further insolvencies. So we're definitely going to see more activity in this area over the next 12 months. What is probably harder to predict is what exactly that will look like. So sometimes helpful to look at England and Wales, because they have been, whilst we had temporary restrictions in relation to winding up petitions, for example, that went on for a considerable period, those temporary restrictions were dropped much sooner in England and Wales. And they have seen, just generally speaking, a lot more insolvencies coming through. What is interesting is some of the provisions that are provided by that SIGA legislation, for example, restructuring plans, they haven't really seen a huge amount of those. Seems that part of the reason behind that is that that could be a fairly expensive procedure. And so we may not see much of the new types of provisions being used at this stage. Maybe later down the line, when there's been more cases that have been tested, more cases before the courts, we may see that is something that businesses will use more than likely. But I think for the meantime, what we will see is probably the usual things, that the voluntary liquidations, which have been pretty busy during this period, continue to be busy. We'll maybe see some CVAs, but as mentioned, HMRC dependent really in relation to the viability of those. And we may see an increase in pre-pack administrations for the reasons that I stated earlier. So we certainly expect to see more activity in the sector, Vincent, but it's hard to be too precise about what insolvency procedures you're more likely to find being used during this period.
Okay, thanks, Richard. Thanks. Another question here is, what do you see as the key benefits of getting early legal advice on these matters?
I think, well, like Kathryn sort of highlighted in from both the debtor and creditor consideration position, if you get early advice, you have more options. So certainly from a debtor point of view, whenever a company is facing a winding up petition, it's almost like a gun to the head type scenario. You have very little time. You have to be very reactive. There still are options, but you have to act very quickly in that period. Whereas if you can see like a general trend of downturn and you go and get early advice from an insolvency practitioner, there may be other ways to address that. You may be able to agree an insolvency procedure that's better and more favorable for the company whenever you don't have that additional threat of a winding up order. From a creditor perspective, again, it probably just helps you. In some cases, it may help you get to the top of the queue over other creditors because you put enough pressure on, you get a payment, you actually end up getting more back than you maybe would have later down the line in an insolvency procedure. So there's definitely benefit to that. As Kathryn mentioned, just reviewing contracts and checking that you're as secure as you can be. So retention of title clauses in contracts, just making sure that they are valid and legally enforceable. Make sure that your position is secure, and also probably just even just a general review around, you know, the exposure that you have as a business to your trade debtors, just making sure that's as limited as you can. So again, looking at these before things become particularly acute is going to be probably better for you in the long run.
Super. Thanks, Richard. Couple more actually, plenty of questions coming in today. Should you continue to pay a company in administration? And what is the best tool to use to check a company's current financial status? Do you have any thoughts on that, Richard?
Well, there's dealing with the second part of that question, then firstly, the checking the financial status. I mean, there's obviously the information that's out there in the public domain around company accounts, etc. And you can do various checks, you can do searches to see if there's any proceedings against them, any judgments against them. But I think in most cases, especially because accounts don't have to have all the detail for most companies probably that you're dealing with, there's not a lot of detail, say, available on Companies House, then I think it's getting information from the business that you're dealing with and making that a condition of trading with them. So you want some visibility. You want to make sure best you can that they are in decent shape. That all being said, there's always risk associated with trading with any business, and you know you may find it could have a bit of an adverse impact in that people will not want to trade with you because you want to interrogate their information too much. So we find we often get that question, like, what can you find out about the company to help us assess where they're at? And unless there are, you know, sets of proceedings out there against them, typically you're limited in terms of the information that you can get, and you are quite dependent on debtor information, which is probably one reason why, as best you can as a company, trying to limit your exposure is probably the best advice. In terms of dealing with a company in administration, well, as mentioned, whenever an administrator is in an office, then you know the company is continuing to trade, and as I mentioned, provided you know say if they're supplying to that company and they're continuing to pay for that, well then there's very little you can do to challenge those contracts. If you can show that there is some particular hardship that you're experiencing as a result of continuing to trade with that company, then as mentioned, under those SIGA provisions, you could potentially go to court and challenge that, but that's not necessarily going to be very attractive because that's going to be an added expense. But again, it depends very much on what you see as the company's exposure. If you do see a situation where your company is going to unnecessarily suffer that hardship, and there's going to be a significant cost to the company, then that would be something certainly to get some advice on to see what you can do.
Yeah, absolutely, absolutely. This seems quite specific, this next question, but sure, we'll give it a go, and it might be one to follow up on afterwards, but sure, give it a go. If a subcontractor has retention held against them and they go into administration, can the main contractor withhold payment of retention from the administrator, even though there are no current defects? Reason being that the main contractor will now pick up liability. Any latent defects that may arise during the statutory liability period, 6 or 12 years, depending on how the contract was executed. That's quite specific. So, don't want to put you in the spot there, Richard, but it might be one to follow up on afterwards.
Yeah, that is very specific. And definitely one that I mean, I can make some general comments around it, but I mean, whoever's asked that question, I think that's definitely one to get
one to follow up on. I think, absolutely,
and get that. I mean, I think in principle, yes, I think they may have to do that, but I mean, it's very hard to give an opinion on that without actually reviewing contracts and looking at that in a bit of detail. But those are, I mean, that's an excellent question, and those are the kind of things certainly that, you know, businesses should be seeking some specific legal advice on to see what their position is.
Okay, super.
I just hopefully successfully avoided saying too much there.
Yes, that's all right. That's great. Thank you. Thanks. I think that's everything. We're running out of time here, but as I say, we'll share the slides around, and if anyone has any questions, they can pick up with Richard and Kathryn. But thank you very much, Richard and Kathryn, for that. That was really informative and very helpful indeed. And thank you everyone for attending. So thanks to Milselig for their guidance on this, and we'll end it there. Thank you.
Thanks, Vincent. Thanks,
Thank
everyone.
you. Bye.
Thank you.